Well, thank you very much for joining me in this video. I want to thank you very much for investing your time. I think any of you who've watched for any length of time know that I'm a big believer in investment real estate. I think if you want to retire one day with passive income that will allow you a real quality retirement, building an investment portfolio is the way to go. Having said that, there's some challenges to being a residential landlord, and none less than the legislation that governs us, the Residential Tenancies Act. We need to understand the Residential Tenancies Act is consumer protection legislation. And because there's more tenant voters than there are landlord voters, don't expect it to change anytime soon. And if and when it does, it probably is not going to change in favor of the landlord. So it's something we have to work with. We need to understand it and work with it. You know, I had the privilege of speaking with the Attorney General for the province of Ontario not long ago, and it was a privilege to speak to him. He's the guy who oversees the implementation of the Act. And as we chatted, I came to learn that before he went into politics as a practicing lawyer, he said he set up the Landlord Association in the municipality where he worked. So he understands the issues from a landlord's perspective. Gave me an opportunity to key down some specific areas of the legislation I was concerned about. And there were two things I wanted to talk to him about. The first was the issue of implementation. I said, you know, the legislation gives provision for example, for a landlord to evict a tenant for a number of reasons, disturbance, non-paying the rent, and so on. I said, why is it that if the landlord issues an N4 to evict the tenant, why does it take 8 months to evict the tenant? But if the tenant has an issue against the landlord, it'll be dealt with by the board within 72 hours. He didn't deny that. He said, well, it's a matter of enforcer. We've got a lot more enforcers for tenant issues than we do for landlord issues. Well, that may be the cause, but why don't we fix it? Hire some more enforcers. And then he challenged me. He said, I don't think it takes 8 months. I think we sped it up. I think we got it down to about 4 months. I said, if you call in and listen to the on hold, it'll tell you as a caller that if you haven't heard from them within 8 months, give them a call again. He was shocked to hear that, but that's what it says. And I gave him an example. I said, let's take no-fault evictions. I said, we had a situation where we sold a property that was rented out. And so the tenant was given the 60-day notice requiring them to vacate because the buyer was moving in. So they had to move out by the end of June. Well, they didn't. And so I contacted them and talked to them about it, the tenant, and they said, we don't have to move out. We called the board, and the board said, listen, you don't have to move out. It's going to take them months to evict you. Well, the Attorney General was shocked to hear that. But I said it right on the form. When you fill out the form, it says you don't have to move out within this time frame. You can challenge it. Why do we have that? Why don't we say you have to move out, but if you feel it was a bad faith notice, then you can challenge it later and you can be reimbursed for the problems that you faced if it was not properly done. But the people's lives are at stake. Somebody's moving in, they've got their house sold, and all of a sudden the tenant, because it's inconvenient for them, doesn't move out. I said, that's a huge problem. Then I said, the second issue is below market rent. We've got people, landlords, new purchasers, coming up with all kinds of ways of evicting tenants, you know, moving a family member in for a year, whatever it might be, because the rent is so chronically low. And I said, there needs to be something done. He said, well, any property that's built after November the 15th, 2018 isn't under rent controls. I said, yes, what that does, though, is it creates two tiers. It doesn't solve the problem. Give me an example. I said, my smallest rental unit in a duplex, upstairs of a story and a half, slanted ceilings, bedrooms only 8 by 8, bathrooms small. And I said, it charges higher rent than a duplex I have where the upstairs apartment is 3 spacious bedrooms. It's got an in-suite laundry. I said there's no comparison between the 2 units, and yet the 3-bedroom is paying less rent. That shouldn't be, but it's locked in. Something needs to be done. So I gave him a suggestion. I said, why don't we set up a rental advisory board, and any landlord can call the board, maybe pay $200 or $300 to cover the cost, and the board can come in and inspect the rental dwelling or unit and say this is the market rent. And then the landlord is allowed to bring it up to market rent over a 3-year period, the same way MPAC does with taxes. I said, that way the tenant isn't being evicted. He's got the opportunity to move out if he's going to find it too expensive or stay put. And it works a lot better. And the Attorney General says, that's a really interesting idea. I'll give it some serious thought. And I believe he meant it. However, government, landlord-tenant issues, don't hold your breath. But it was nice to be able to at least air some frustrations and some thoughts. And I want to thank you for sharing this time with me, and I look forward to talking to you again next week.